Hi, I'm Emily McFarling, and today we are going to be talking about trial preparation and litigation in the family court. So I'm going to give you some pointers on how to put together everything you need for your litigation and for your trial if you have a family court case, specifically a child custody case or a divorce case. So as your case goes through the system, there's a certain pattern of how things go, and it's useful to get familiar with what to expect is coming up in your case. So a divorce case or a child custody case, it started through the filing of a complaint for divorce, a complaint for custody, or a paternity petition. And that's the beginning of the case. So one side will file their complaint or their petition. The other side gets served that and has a certain amount of time to respond to it. And the other side generally will file an answer and a counterclaim asking for what they want in that case as well. And so those beginning pleadings are what start the case moving forward. And there's deadlines that are triggered by the service of those pleadings, and there are things that both parties have to do, and then there's things that the court has to do. So very soon after the complaint and the answer are filed, the court will generally set what's called a case management conference. This is usually the first hearing that you have in court, unless somebody's filed a motion before it. After the first hearing, whether it's a motion or a case management conference, if you have children at issue, the judge will refer you to the Family Mediation Center for a settlement conference or a mediation in order to try and resolve custody. They can also refer you out to try and settle other bigger issues. If you do have a settlement conference or a mediation, the court will generally set a return hearing to check back in and see if you've settled anything, what you've settled, and then figure out what still needs to go to trial. And then eventually there'll be a discovery process that's going on during this whole time frame where you guys are exchanging information. And at the end of it, then anything that isn't settled is set for a trial or an evidentiary hearing. And at the conclusion of that trial or evidentiary hearing, then the court will make a decision. The case management conference. So this is that first hearing. It gets set by the court. So you will receive an order from the court or a notice that schedules this case management conference. And it's going to have a date and time and a location. It's going to have some information or directions on what the court wants you to do in advance of it. So you want to read it very, very carefully. Make sure that you have complied with everything the court is asking you to do in it. The rules require for certain things to be done very, very early in a case, such as the filing of a financial disclosure form, or we call that an FDF. So this must be filed within 45 days of service of the complaint. So it's super important that you start working on this right away at the beginning of the case, that you have it filed within that 45-day time period, and certainly that you have it filed before that case management conference, because the judge is going to use it during that hearing. If there's any temporary orders or things that need to be set, that financial disclosure form is the roadmap for the judge to figure out the financial situation of both of the parties. The court might want to know what issues are potentially settlable, and so they might try and get information from both sides during the case management conference to determine if there's issues that might settle, and if so, then send them out for a settlement conference. We have a required mediation program at the court through the Family Mediation Center, so if you have child custody issues, the court will send you a referral to the Family Mediation Center to do a mediation and try and resolve those child custody issues. But for other issues, for property division and other things, the court can also send you for a settlement conference on those as well. And whether or not there was a motion filed, the court can make temporary orders at that case management conference as well. You don't necessarily want to rely on it. If there's something that you really need and it's super important, it's probably best to file a motion. But the court is allowed to make temporary orders even without a motion at the case management conference. Now, a motion. What's a motion? A motion is a request that one of the parties files asking the court to do something. Now, in the stage of a case where you have a complaint that was filed, an answer, you're in the beginning phases of a case, most of the motions that are filed during that stage in the beginning proceedings before you ever have a trial are motions asking for temporary orders. So if you need a child custody schedule, you need child support, you need spousal support, you need to determine who gets to stay in the house, who gets possession of a certain car, things like that. And those are going to be requests that you make for orders that will get you through the proceedings until trial when the judge makes final orders. So you file a motion asking for temporary orders. This is what we're going to do until we have final orders. And so if you have anything that you and the other party haven't been able to agree on, and you really need to know how you should be acting, what you should be doing while this divorce or custody case is proceeding through court, you should file a motion so that you can get temporary orders that say exactly what the parties should be doing. The case management order or trial management order is an order that the court will issue at the case management conference or following the case management conference. And what this is, it's an order that spells out certain deadlines for your case. So it should tell you the discovery cutoff date in this trial management order. That's a really important date because that's the date that all the discovery has to be completed by. And so you want to make sure that anything you're doing is geared towards having it 100% complete by that discovery cutoff date. Some judges will put a return hearing or a calendar call in it, and other judges will actually schedule the trial date in advance and have a trial date that's pretty far out that's in the trial management order as well. There's also going to be other deadlines for when you have to disclose witnesses, when you have to exchange documents, and when you have to file a pretrial memorandum, and when you have to give the other side your exhibits for trial. So if you have a child custody case, we have a statute in Nevada that spells out the considerations that the judge has to look at in making that child custody determination. These custody factors, they're spelled out in the statute NRS 125C 0035. And so those factors that they're going to look at are the things that you're going to want to make sure that you're presenting facts, you're presenting things in your case that go towards as many of these factors that apply to your case. So those factors are the wishes of the child, if the child is of sufficient age and capacity. It's not a set amount of time, it's not a set age for a child, but they look at the age and the capacity of the child if they're going to look at the wishes of a child. Any nomination by a parent, which parent is likely to allow the child to have frequent associations with the non-custodial parent, the level of conflict between the parties, the ability of the parents to cooperate to meet the child's needs, mental and physical health of the parents, physical, developmental, and emotional needs of the child, the nature of the relationship of the child with each parent, the ability of the child to maintain a relationship with any sibling of the child, any history of parental abuse or neglect of the child or a sibling, whether a parent has committed an act of domestic violence against the child, parent, or the child or person residing with the child, and whether the parent committed an act of abduction against the child or a sibling. So those are all the factors that the court will go through to look at, but they also can look at anything that affects the best interests of the child as well. So if there's something that doesn't fit into that list that you think is important, you certainly can present that as well, and it can be something that the judge can use to make a decision. If you are asking to relocate your child to another state or to an area that's going to substantially impact the visitation or contact that the other parent can have, then there's a specific mechanism and analysis that the court has to go through in order to decide if they're going to allow you to relocate with your child. So there's a list of factors. That list of factors is spelled out again in a statute, and that's at NRS 125C007, and it lists what the court has to consider in reviewing your request to relocate. So the things that the court will look at is how the parent is likely to benefit. What the court will look at is how the move is likely to benefit the quality of life for the child and parent, whether the motives of the moving parent are honorable and not intended to frustrate visitation, whether the motives of the non-relocating parent are honorable, and whether opposition is intended to secure a financial advantage, if there's a realistic opportunity for the non-moving parent to maintain a visitation schedule that preserves the parent-child relationship, and whether the moving parent will comply with substitute visitation orders, and finally, any other factor that helps the court determine whether to allow the relocation. So if you're putting in a request or you're opposing the other parent's request to relocate, these are the factors that you're going to want to make sure that you're presenting facts that go toward each of them. If you have a case where either you or the other party is requesting alimony, then there's a statutory list of factors that the court goes through to determine whether or not, how much, and how long to award alimony for. So the factors that the court will look at in deciding alimony, they're going to look at the length of the marriage, the earning disparity between the parties, the spouse's need for financial support versus the other spouse's ability to pay, the receiving spouse's education during the marriage and current marketability, the receiving spouse's career prior to marriage, the income, earning capacity, age, and health of each spouse, and whether the receiving spouse stayed at home with the children. Alimony is one of the harder things to predict in family law. There's no set calculation for it. It really is just this list of factors that the court's going to look at for it. Some of the judges lean heavier on alimony, some of them lean lighter. So you probably want to do some research and see where your judge seems to fall on alimony in general when you're going into a case asking or defending against a request for alimony. Now, discovery. So in the court case, after everybody has filed their complaint, answer, been served, there's this period that opens up that's called discovery. And this is the exchange of information between both of the parties. And it's how you get the information you need to build your case, and you give the other side information that they need to build their case. And then both parties are able to gather documents and evidence from outside sources as well. So it's the process of getting the documents, getting other types of evidence, and finding and disclosing the witnesses that are going to testify at trial or could potentially have information. So how do you get things from the other party during the discovery process? So the first way to get things from the other party is called a request for production. Generally, this is requesting documents from the other party, but it can be production of other things, including electronically stored information, photos, videos, and other data. And so what you do is you send out a request for production. They have 30 days to provide the responses to it, which would mean providing those documents or providing any objections that they have to it. Now, both parties are only obligated to provide documents that they actually have possession of or reasonable access to. So you can't require the other person to go on a huge search for something to get something that they don't really have readily available to them. So it has to be somewhat reasonable in what you're asking for, that they have access to it. But if they do have access to the documents and if they're relevant to the case, then there's an obligation for them to be turning them over to you in response to the request for production. The second type of discovery that is done where you're sending out requests to the other side is called interrogatories. So these are open-ended questions that you ask the other party, and they then have to provide answers to them. In a divorce or a custody case, this can often include, list all of the property and debts that you have, give me the bank account numbers, your bank account balance, how much are these things worth, what's your income, what's your requested timeshare, why is it best to have this type of custody arrangement. Things like that are the types of questions that are generally relevant in a divorce or custody case that you would ask in interrogatories to the other side. And then the third type of requests that you send in writing to the other party are called requests for admissions. So these are also questions, but they're admit, deny, closed questions. They're not these open-ended, tell me about it type questions that the interrogatories are. So in a request for admission, you want to ask them to admit something. And so then when you have an answer to those that, you can ask, many questions, and you ask them to admit each one, they then can be locked into the answer that they give in admitting something that you ask for in admissions. Now, one thing to know, a request for admission, if they are not answered within that 30-day time period, they're automatically deemed admitted, which means that the court can just assume that all the answers are admit in the request for admissions. Now, in a child custody case, it's not necessarily something that the court should do just across the board, accept admissions because someone didn't answer if it's not in the best interest of a child. So the court still has to look at the best interest of a child above and beyond any kind of litigation technicality that someone didn't answer discovery. But anything else, the financial issues, other things in the divorce case, they certainly can take unanswered admissions as, the concluding information for a case. You want to be really, really particular that you answer requests for admissions by that 30-day deadline. And your interrogatories and your document requests, if you don't answer within the 30 days or you don't give sufficient answers or documents, then there's a process for them to go in and compel you to answer. So you definitely need to do your answers to those as well. All of these are required parts of the court process. And so if you receive requests, you need to be answering them and making sure that you're complying with the court process. Now, one other way that parties generally get information from the other party or from third parties during the litigation, it's called a deposition. What a deposition is, that the person requesting the deposition will call the other party or the person who is supposed to be deposed into their office in a conference room or into a deposition facility. There's a court reporter that transcribes it. You can also have it video recorded at the same time. And then they are asked questions under oath. And the answers that are given during that deposition have to be the truth. And so if you make statements, have testimony at trial that is different than the sworn testimony given in a deposition, that can be a huge problem. So it's a very important tool for getting answers that are sworn to be the truth earlier in the case than when someone actually testifies at trial. So how do you get things from other people in discovery? So if you need to obtain documents from somebody who is not the opposing party in your case, the process for doing that is called a subpoena. So you prepare a subpoena, and you have to actually send a notice of intent to serve subpoena. You have to send this notice to the other party 7 days before you actually serve the subpoena. So this process takes a little bit of time because you have to do each step at the point that you need to do each step. So you prepare the subpoena, you send the notice of intent to serve it to the opposing party. You wait 7 days. to give them time to do an objection. If they don't object to it, then you serve the subpoena on that third party that you're trying to get the documents from. If there is an objection to it, then of course you have to bring that to the court and decide whether or not you can actually request those documents from the third party. And when you're requesting any documents, whether it's from the opposing party or from third parties in a subpoena, you want to make sure that you're reasonable with what you're asking for, that you're asking for things that are relevant, and you're asking for documents that aren't just so many documents that it's going to be hugely difficult for them to get them to you. And then third parties are allowed to charge you for the copies of the documents that you ask for. The opposing party is as well. So if you go in and you ask for 1,000 pages of documents, they can charge you per page for those 1,000 documents in order to give them to you. And that's a reasonable thing for them to require in order to give you those documents. Now, the other things that you would be looking for from other people would be witness testimony. So you can list your witnesses that are friendly to you. You would want to list them and make sure that they're available and they come appear for trial. If there are witnesses that are not necessarily friendly, meaning they're not necessarily going to show up for trial unless you require them to, then you can send a subpoena to a witness that compels them to come testify as a witness during the trial or during the evidentiary hearing. And that subpoena has to be served on that person. And when it's properly done, then it requires that person to appear and testify at trial. And for any witnesses, whether they're ones you're subpoenaing or whether they're ones that are showing up to testify willingly, you have to make sure that you disclose their identity and the information that they potentially have throughout the discovery process. You can't just show up with someone at trial and say, oh, here's this person that they're not expecting to show up at trial. So there's a whole process in disclosing who might be a witness at trial as well. When you receive discovery requests from the other party, you're required to respond within 30 days. You can object to the request in your response, but you have to respond. So if you do have objections, there's certain cases that spell out some standard objections that you can have to discovery responses. You're going to want to make sure that you're using an appropriate objection to it. You know, an appropriate objection might be it's not relevant to the case at all. You know, if they're asking for something that's just ridiculous and doesn't have anything to do with what you're fighting over, it could be not relevant. You know, if they, let's say, you had an affair and they want records of, you know, your phone calls with the person you had an affair with, unless it has to do with some financial order or custody order, or, you know, something, it's not really relevant to the case. And so those are things you can object to based on not being relevant. And there's quite a few other objections you can make as well. But if you don't have a legally valid objection, then you have to provide the responses within that 30-day time period. If the other side, if the other side doesn't respond to your discovery requests, the process then after the non-response or the insufficient response is that you file a motion to compel discovery. And so that gets filed, it gets heard by a discovery commissioner, not the judge who's hearing your case. And the discovery commissioner then can make orders such as requiring the other side to provide the documents or information within a certain time period. They can award attorney's fees. They can limit the scope of what your requests are if it turns out that the other side has a valid objection to the scope of what you're asking for. And so that gets heard by the discovery commissioner, and then eventually you end up with hopefully fully responded to requests on both sides that comply with what's relevant to the case. Now, in your case, there is a rule for divorce cases. It's NRCP 16.2. It's a rule that spells out what both parties are required to disclose to the other party without even being asked. And these, the deadlines for this disclosure are very early in the case as well. So you have to provide a list of witnesses. You have to list all the people that you plan to call to testify at your trial. Something to note, if you have witnesses or people with information, things like a notarized statement or a letter from a third party that has to do with your case is not sufficient. If you have somebody who has information about your case that you need the judge to hear, they have to come testify in the evidentiary hearing or in the trial. It's not something you can just replace with something that they write up. So they have to actually be a live witness, because the other side has the opportunity to cross-examine them. If you just submit a letter or something like that, then the other side doesn't have that ability to cross-examine them. So any witness testimony that you have, it has to actually be a witness who shows up to be asked questions by you or your attorney, and then ask questions by the other side as well. And when you disclose the list of witnesses, you give a short summary of what they're going to be testifying about as well. You also are required to disclose your list of exhibits. So these are the documents that you plan to introduce at trial and prove your case. And you have to provide a list of them, but you also have to give copies of these documents to the other side. Now, when you are preparing your exhibits, you're going to want to read through that trial management order to make sure you're preparing them properly. In the family court, they have a numbering or lettering scheme so that no one gets confused as to whose exhibits they are. And so if you're the plaintiff, then your exhibits are going to be numbered 1, 2, 3, 4, 5. If you're the defendant, your exhibits are going to be lettered. A, B, C, D. If you get past Z, then you're going to go A, B, B, C, C, and so on. And so make sure that you're using the proper lettering or numbering, depending on if you're plaintiff or defendant. And then all of your exhibits, they should be put into a book with an index that's easy to use, easy to manage, and they need to be provided in advance to the other party, and generally provided in advance to the court as well. And you're going to want to have a copy for yourself. You're going to want to have a copy for any witness that is sitting on the witness stand, a copy for the opposing party or opposing attorney, a copy for the courtroom clerk, and a copy for the judge, so the judge can be looking at it once it's been admitted during the trial as well. So that's 5 copies. You're going to need to have 5 copies of your full book of exhibits heading into an evidentiary hearing or a trial. The trial exhibits should have an index, and in the index, it not only should it list what letter or number it is, it should have a name for the document. Ideally, you've bait stamped your documents as you're going through discovery, and that's just putting page numbers on them so that you can reference what page number it is. And so your index will include that bait stamp number on it as well. And then it's useful to have a cover sheet index that also allows you to mark off if you've offered something in to be admitted, if it was objected to, or if it was admitted. So when you give this book of trial exhibits to the court clerk at the beginning of an evidentiary hearing, and they mark them up, they take them, they kind of receive them into their system, but that doesn't actually get you anywhere. The judge is not allowed to look at the trial exhibits until they've been admitted into evidence. And so the process for trial exhibits to be admitted into evidence, there's 2 different ways this can happen. One is that the parties stipulate that they're admitted into evidence. So maybe at the beginning of the proceedings, beginning of the trial, the judge will say, do you guys stipulate to any exhibits? And if so, then you list off which exhibits got stipulated to, and then those are admitted into the record. And from that point forward, they are in the court record and the judge can look at them. If you don't have any stipulations for exhibits, then the second mechanism to get them admitted is that when you come to the point of needing to have a witness review that exhibit, then you would offer it for admission. So let's say you have an exhibit that is photos of damage to a car, and you have a friend who's going to be testifying about them because this friend took these photos. And so when that friend is on the witness stand, you are going to ask them, hey, did you take some photos of this incident where there was damage to the car? They're going to say yes, and then you're going to turn to the judge and say, I'd like to offer Exhibit A to be admitted into evidence. The other side can object to it. The judge will make a decision on any objection, and then if they overrule the objection, or if there is no objection, then the judge will admit it into evidence. And at that point, then the judge can look at the document. And so if the judge has your exhibit book in front of them, then they can open up the book and look at that document then as you continue on with the witness testimony that you just started with getting this exhibit admitted. Now, one thing to point out for your exhibits is that you want to make sure that you know where in the testimony of yourself, the opposing party, or any third-party witnesses, where you're going to be asking for these exhibits to be admitted, and make sure that you roadmap that so that you get them all admitted. It's something that a lot of people, when they go to trial by themselves, they overlook getting their exhibits admitted because they're focused on the testimony, or they didn't mark a point in the testimony where they're going to be asking for that document to be admitted. So you're going to want to map out where in the testimony you're going to ask a question about the exhibit, then ask for it to be admitted, and then continue on with more in-depth questions about the exhibit after the judge is allowed to look at it because it was admitted. Before an evidentiary hearing or a trial, the court requires that you file a document called a pretrial memorandum. This is usually due about a week before the trial, and it tells the judge where you stand on the issues that'll be decided at trial. So you list in it what are the issues that the judge will be hearing, and then what do you want? What do you want the judge to order? And you can roadmap out what witnesses are going to be testifying, what exhibits you're going to be presenting. You list out all of your exhibits. And so you want to make sure that that pretrial memorandum spells out enough information so the judge has a roadmap of what you're going to be presenting at that trial. The other thing that you need to make sure is updated going into a trial is your financial disclosure form. So if you had filed one at the beginning of the case, and that was now 6-9 months ago, even if nothing's changed, you're going to want to file a new financial disclosure form that is current and shows your current situation. I mean, you'll have been, there might be things that have changed minimally during that time period, and you're just going to want to make sure even those smaller changes are reflected in an updated financial disclosure form heading into trial. Some judges will set a calendar call. What this is, generally, it's a hearing before a trial where the judge checks the status of, are the parties ready to go to trial? Is there a chance that they're going to settle before trial? Do they need to do more discovery, or are they ready to go? Some judges will have the calendar call and then give you the trial date at the calendar call very quickly after the calendar call. Some judges will already have given you the trial date and then just have the calendar call to double check if you're ready for it. And then some judges do this thing, it's called stacking their trials. So if you hear the word stack, that you're stack 1 or stack 2 when you're getting a trial date set, it means that they are setting multiple trials on that same date. So if they say you have a March 1st trial date at 1:30 in the afternoon, stack 2, what that means is there is one other case that is also set for March 1st, and they're going to, if they don't settle their case, they're the ones going first before you. And so your trial is going to get kicked to another date if theirs doesn't settle, if you're a stack 2. So be really mindful if you hear about stacking, and if you have something that's time sensitive, you want to make sure you get a stack 1 trial date. Or if you have something that's for sure not going to settle, Now, when you actually show up for trial or for your evidentiary hearing, one thing to be really mindful of is show up early. You do not want to be running into that courtroom with the judge already in the courtroom. It just sets up an appearance that is not good from the very beginning. You want to take time to get yourself collected and ready and in the right mindset, and make sure that everything is together so that when they open those doors to that courtroom for the trial, you can walk on in because you've already been there ready to go before that. If you're on video, you want to make sure that you have a quiet, private place in order to appear for that evidentiary hearing. You should not have any other people in the room with you who are off camera. It needs to be a private space where you're appearing on video for your hearing. And if you are not talking, anytime you're not talking during the video proceeding, you want to make sure that you're muted. There is nothing more disturbing and creating of a negative appearance for you than to have the sounds of your room, whatever it is going on in your room, you coughing or sneezing or taking a sip of water, to have that sound echoing through the courtroom, because that's how it sounds like when you're on video, any sound that you have in there. So make sure that you are on mute and you're not having your sounds interrupting the proceedings in the courtroom. And then make sure that you have your documents. So if you have an exhibit book, you're going to want to make sure that you have distributed all the books to the opposing party, to the court clerk, to the judge on the witness stand if you're there in person, or to the witnesses who will be testifying if the witnesses are going to be testifying by video, and that you have your own documents for yourself to reference as well. If you have witnesses, make sure that they arrive early as well. You don't want to be ready to put on a witness and have them not there, not ready to go. So if you're appearing in the courthouse, if your witness is appearing in the courthouse, make sure they're there waiting in the hallway. Witnesses cannot come inside and witness the proceedings before they testify. They need to be sitting in the hallway, or if they're appearing by video, then they need to be available on video, but not actually watching the proceedings before they testify. After a witness testifies, depending on the situation, some witnesses may be able to stay in the courtroom after their testimony, and that's something that they should ask the judge after they testify. And then for you and for any of your witnesses that are appearing on your behalf, just make sure that you're dressed nicely. If you're fighting a custody case, and you're the mom, you're going to want to look like a mom. You're going to want to look like you fit the role that you're wanting to ask the judge to confirm to you. And you want to show the respect for the proceedings and the respect for that judge by dressing in a way that shows respect for it, by having nice clothing on and showing that you care, that this proceeding is important to you. How to act in court. And this is whether or not you're physically in court or you're appearing by video. Number one is always be courteous to the judge, to the opposing party, to everyone involved in the proceeding. It really can make a big difference if the judge sees you behaving in a way that that is not respectful of the other people that are there, particularly if you're fighting over child custody. But even any kind of case, it's really important to be courteous to everyone around. You want to follow the directions of the courtroom marshal. So the courtroom marshal is there to oversee the proceedings and is in the courtroom during any proceeding that you have. And if the marshal directs you to, go to the witness stand or to sit down or stand up or anything, always follow those directions. Anytime you are speaking during a proceeding, you want to speak to the judge. Don't turn and speak to the other party in the case or the other attorney. You speak to the judge, unless you're questioning a witness when you're speaking to the witness. Or you're answering questions on the witness stand, speaking to that attorney that's asking you questions. But any other time, you're speaking to the judge. You also want to make sure that you know the rules. So there's certain rules that they come up over and over again in family court cases. There's the Nevada Rules of Civil Procedure that spell out the procedure for civil cases. These specific ones that we talked about earlier, this NRCP 16.2, which are the discovery rules for mandatory disclosures in divorce cases, and NRCP 16.205, which are the same set of rules but that apply to custody and paternity cases. We also have specific court rules in Clark County. They're called EDCR, 8th Judicial District Court Rules. And the set of rules that govern family court proceedings all begin with 5. So 5.2, 5.15, something like that, right? So you're going to want to review the EDCR 5 rules. And then we have our statutes. The ones we went over earlier are just a few of them, but there's statutes that apply very specifically to anything that you're going to be arguing over in family court. So Chapter 125 has to do with divorce cases. Chapter 125C has to do with child custody cases. And Chapter 127 has to do with paternity cases. So if you're preparing a case to present yourself, you're going to want to read those statutes and those rules and be familiar with them walking into court. Now, when you get to the trial, there's a certain format that the trial goes in. Now, we've all watched these television trial shows, and it's going to be similar to that. So at the beginning of the case, first off, if you're in initial proceedings, then the plaintiff goes first. If you're in a case where somebody has filed a motion to modify custody or some kind of motion asking to enforce or modify orders after the decree of divorce or after the initial child custody decision, then the person who filed the motion would go first in those proceedings. And so in those modification or enforcement proceedings, it's different. But in the initial proceedings, the plaintiff goes first. And so you start by giving an opening statement. So first, the plaintiff gives the opening statement, and then the defendant gives an opening statement. And in your opening statement, what you're doing is you're telling the judge about the main issues and the facts of your case. You don't give arguments in the opening statement. You're not arguing things. You're just presenting, Judge, this is what you're going to be hearing. This is what we're talking about today. If you're going to be doing an opening statement, you're going to want to practice. Make sure that it's prepared and you know what you're going to say in that opening statement, and that you're comfortable. You're comfortable speaking to the judge, and you're comfortable articulating your opening statement. And when you're giving your opening statement, you're going to want to make sure that you are speaking to the judge, not to anyone else, but look, make eye contact. Make sure the judge is hearing you, because you're actually speaking directly to the judge. After both parties have done their opening statements, then the questioning of witnesses begins. So in initial proceedings, it would be the plaintiff who calls witnesses first. And so generally in family court proceedings, the two parties are the primary witnesses, and there may or may not be other witnesses. If there aren't any other witnesses, then it's a relatively short proceeding, and whoever's the plaintiff gets to decide if they're going to speak first and be questioned first, or if they're going to call the other party first. And that's certainly a strategy decision. Judges, people in general, they say often remember things that they hear first and the things that they hear last a lot more than things they hear in the middle. So the most important stuff you're going to want to put right at the beginning of your case if you're the plaintiff. If you're the defendant, maybe you want to get that most important stuff at the end of your case and not have it muddied in the middle of the case because you're going second after the plaintiff. But strategically, you're going to want to figure out when you're going to call each witness. So each witness, when they get on the witness stand, the person who called them gets to do a direct examination of that witness, which means they ask them open-ended questions. You can't ask these tight yes or no questions in direct examination. Now, once you've finished your direct examination, then the other side gets to do cross-examination. These can be yes or no questions, and honestly, strategically, they're better to be tight yes or no questions because you don't want to give an adverse witness the ability to just talk and explain things fully if you can just keep them locked in with a yes or a no. On cross-examination, the questions are limited to the subjects that were raised during the direct examination. Now, after a cross-examination, then the party that called that witness has the ability to do a redirect. But again, it's only limited to subjects that were raised in that cross-examination. Now, one thing to point out, if you have a case where the only or the primary witnesses are just the two parties, is it's possible if both parties want it, or if one of the parties is insistent on it, that you call both parties twice. So the plaintiff calls themselves and then calls the other party, and then their case is done, and then the defendant goes, and the defendant can call themselves and the other party. That's certainly a way that it can go, and how our traditional litigation is set up. That's the way that it makes the most sense, or is laid out. But generally in family court proceedings, it just doesn't make sense to have both people go up and testify twice. So often the parties will agree, and the judge might even suggest that you call the two parties once. So the plaintiff is going to go, they put on their case, and then when the cross-examination comes around, it's not necessarily limited to just what was discussed in direct examination, because this cross-examination is actually combined with the opposing party's direct examination for their case as well. And so it's a slightly different way of doing things. So one party goes, their side gets to ask questions, the other side asks all their questions, not just limited questions, and then the plaintiff gets to follow up with any other questions on it. And so then that witness is completed instead of having to come back a second time. That's a standard way of doing it in family law cases. Now, going into trial, you're going to want to know your objections. So when you're presenting evidence, you're trying to get a document admitted, you have a witness or yourself that's trying to testify to things. If there's an attorney on the other side, they may well be making objections. You're going to want to know what those objections are in order to defend against them. And again, if the other side is putting on evidence that isn't really appropriate, you're going to want to know what the objections are that you can make, so that they're not getting evidence in that really shouldn't be in the record. Now, one thing to point out about objections is that in family court, our cases are decided by a judge. They're not decided by a jury. So in a case with a jury, you want to be super careful that evidence doesn't get heard by the jury that could taint them or be a problem. But when we're dealing with a judge making a decision, we generally give deference and respect to the judge to be able to decide what's relevant, or to give the appropriate amount of weight to the information that they hear, or to the information that they review in documents. And so getting something admitted that's maybe potentially questionable is not necessarily as big of an error, because we can trust that the judge will make that determination as to how important it is to the case, or how relevant it is to the case, and choose to not consider things even though they heard it. And so generally judges will err on letting evidence in versus excluding it, because there's a lot more error that can be found in excluding evidence than in letting it in. But you should know your objections. One big objection that is the most basic one, which is relevance. So this is not related to anything that we're dealing with at this trial. in family law cases, there's a lot of things that are relevant that have to do with what you're fighting over, and so relevance is not necessarily the most common objection that actually gets granted in a family court case. But there can be things that are not relevant that you're going to want to object to. Another common objection is asked and answered. That means that the other side already asked it, it already got answered. We're just repeating it again. And then a third really common one is hearsay. So hearsay gets really tricky. There's a lot of exceptions to hearsay, and sometimes even attorneys and judges don't necessarily understand the nuances of the hearsay rule. And so often it's generally thought of if you have a witness that's getting on the witness stand and says, John said blah, 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 right? You know, that's one witness testifying about what somebody else said. And so generally something like that, it's going to trigger that maybe it's hearsay. Now, hearsay is only a statement made by a third party. So if you have a witness on the witness stand and they are saying what the opposing party said or what you said, that's not hearsay because that's not a third party that they're asserting these statements to. The reason why hearsay is excluded is because you can't go in and cross-examine that third party who made the statement. But if it's one of the parties to the case, well, then you can. And so it has to be a statement made by somebody else who's not involved in the proceedings in order for it even to be hearsay in the first place. And then it has to be a statement that's made, it's being offered for the truth of the matter. And so if you have a statement that you're trying to get into court and you're not trying to get the statement in because you're trying to prove that what they said was true, you're just trying to prove that it was said, right? So if you have a situation where, let's say, my child says they want to live with me and they don't want to live with their dad, right? A statement like that, you're offering that for the truth of it. It's a third party. It's not the other party in the case. That's classic hearsay. There still are some exceptions that you could maybe get that in, but probably not, right? That's a pretty clear hearsay. But let's say you have a statement, and we'll use a statement from the kid again. Let's say you have a statement and you or the third party is testifying that the child said that you're not a nice person, right? And I mean, you're not really trying to offer the truth that you're not a nice person, right? You're just trying to offer the fact that your kid said this, right? There's some reason why your kid is saying something negative about you. And so you want the judge to know, you know, my kid is saying negative things about me, probably because the other party is prompting them to say them, right? That would be why you would be wanting to offer it. So you're not offering it because it's true. You're offering it because, you know, there's got to be some reason why my kid is saying these things that are not true. And so that's where hearsay gets a bit tricky in when it's hearsay or when there's an exception to it. And the rule for hearsay, it's under NRS Chapter 51, where you can look up the specifics on that. Now, getting your documents admitted into evidence. So the exhibits are not entered into the record until you actually get them admitted by the judge. You have to use a witness to get them admitted into the evidence. So they get marked by the clerk when you give them to the clerk at the beginning of the proceeding, but they actually have to be admitted by the judge. And in order for them to be admitted by the judge, often you have to lay some foundation with the witness asking, what is this? Or, you know, something that kind of sets up the background for the document. And then if it's something that needs to be authenticated, then, you know, more information, like when was this photo taken? What does it depict? Who took the photo? Things like that, in order to make sure that it's actually an authentic document. And you would get that information from the witness who's on the witness stand when you're asking about it. And then after you have set up the foundation for it, then you ask the judge to admit the document. And if there's no objection, or if they overrule the objection, then they admit it into the record. And that's when the judge can look at it, and that's when it's in the court record. If you have subpoenaed documents, you're going to want to make sure that those subpoenaed documents are given back to you with a form. It's called a custodian of records affidavit. So these are like bank records, medical records, things like that. So if you have the custodian of records affidavit, because they're records that are maintained by some organization, then you don't have to have somebody actually testify that those are the accurate records. You can testify about those records if you have the custodian of records affidavit. But if you don't, then you have to have the person who maintains those records actually come in as a witness. So it's really important that you have that affidavit in order to avoid having to have extra witnesses or all this extra work, when really you just need this affidavit that verifies that that's an authentic document that they maintained. So once all of the witnesses have testified, then at the end of the proceeding, both sides will do a closing argument. So in initial proceedings, then the plaintiff goes first, then the defendant. In modification or enforcement proceedings, the person who filed the motion, the movant, would go first. And the closing argument is to persuade the judge to rule in your favor. So unlike an opening statement where you're just detailing out the facts, in a closing argument, you are going to argue. So you're going to take the evidence that was presented at trial, the witness's testimony, the documents that were admitted that support your case, and you are going to explain why they support you winning each of the issues. Now, if you are putting on a custody case, you're going to want to go through those custody factors and detail out what facts go to each one of the factors. If you're putting on an alimony case or relocation case, again, you're going to want to go through each of the statutory factors and explain to the judge why certain facts that were presented go towards each of those factors. And then you also want to point out any problems with the other side's case as well. Now, after you have completed closing arguments on both sides, then the judge can make a final decision. Now, this can be done several ways. Sometimes the judge is ready to rule at that point in time as you are standing there in court and just completed your closing arguments. And so the judge can issue the decision verbally from the bench at that moment. Some judges do that quite often. Some judges don't do it very often at all. It's something you can probably get some idea of how your judge often handles things. Another thing that a judge can do is take it under advisement or take it under submission. If they say that, that means that they are going to review everything and then they're going to make a written decision. That written decision will come out either in the form of minutes, which is called a minute order. And if it comes out in the form of minutes, that means one of the sides still has to write it up into being a formal order. Or the judge might actually draft the full final order themselves. And so you'll just receive this full final order that has the decision in it. Another thing that a judge can do at the conclusion of the closing arguments in a case is set the case for another hearing date. And sometimes they even do this before closing arguments. So they might finish the witness testimony or maybe finish the closing arguments and then set another hearing, maybe say a week later, where the judge will announce the decision to the case. And it maybe takes some extra time to do this, but at least it gives the judge a deadline that they have to have this decision by that hearing date. And so if you have one of those hearings set, then you'll show up and then the judge will announce the decision from the bench. And generally then one of the parties or attorneys then has to draft up that decision into a final order after that hearing. Appeals. So I'm not going to get too in deep on appeals because we'll have another video more in depth on appeals. But you have very strict deadlines of when you can challenge orders in a case. So an appeal to the Nevada Supreme Court or Court of Appeals must be filed within 30 days of the service of the notice of entry of order of whatever final order you're appealing. So it's a very quick time period. The notice of appeal is not a big document that takes a lot of time to prepare. It's something that can be turned around relatively quickly, but it has to be filed within that 30 days. There's absolutely no flexibility in that whatsoever. There's a few other things you can do if you want to challenge an order that go back to your same district court judge, such as a motion to reconsider, which has to be filed within 14 days. You could also have a motion for a new trial or a motion to set aside, and those all go back to that same district court judge as well. So if you have a decision that you're not happy with, you're going to want to make sure that you're looking at those options and you're jumping into doing a motion or an appeal right away. So hopefully we've gone over everything to help you in preparing your case to get through either a divorce or a child custody case in the family court in Clark County. And it's something that a lot of people do without attorneys. A lot of people have attorneys with them. And if you're comfortable going it alone and presenting your case on your own, it's certainly something that is doable. But if you have difficulty articulating what you want to say, you want to make sure that you are putting on the best case possible, because ultimately you're fighting over things that are very, very important to you and to your family.